Virginia.
Yes, ma'am.
All right, thank you. You can have a seat. This is cause numbers 25 DCCR 0838 0839, and then there's 21 37809. And you guys are just gonna have to bear with me. I woke up with this, so I didn't smoke 12 packs of cigarettes. I just sound like I did. All right. Mr. Fletcher was previously in court, entered pleas of not true in a motion to revoke probation in the 21 cause number on probation in that case for the second degree felony offense of possession of a controlled substance. And the allegations, give me just a second. There. Okay. Counts 1 through 5 were all pleas of not true. And then I'm just going to try to look back. Were there any pleas of true to any counts, or was that all of the counts in the motion? Is what I'm looking at. Does anybody know? Do y'all recall?
He pled true to any of the counts.
It was,
That's right.
those are the only, there were 5 counts.
Yes, Judge.
I'm going to double check that too. And so we've got count 1 was the new offense of manslaughter. Count 2, offense of criminally negligent homicide. Count 3 was aggravated assault with a deadly weapon. Count 4, possession of marijuana. And then count 5 was unlawful carrying a weapon. And all of those, well, not all of them. We've got the first 3 stem from the same date of September 18th of 2024. And then counts 4 and 5 are from July 4th of 2023. And so we're set for a hearing today on the motion. And then once we get through this motion and do today, we'll figure out what to do with the new offenses. But we're going to go on that motion first. I've gotten the updated report from probation. Have you both had an opportunity to review that report?
I have a copy of the update.
It should have been emailed to you, but I can
Stay at the college. Oh, it sure was. On 1/6, is that what you open? Oh, that's a Johnny's report. I don't have an updated report.
it was some time ago. It looks like the day of the report was actually October 24th of 2025.
Yeah.
November 24th. Looks like November 24th.
Date of sentencing was supposed to be November 24th. We were set initially then and then reset it for a special hearing to today. So for witnesses.
I'm sorry.
You're good. So
I don't think I got that.
okay.
Returns.
It's, can you just come make a copy of mine if you can't find it, please? Okay, thanks. I'll let you take a look at mine, and Miss Warner's going to bring one for you. And there's a letter attached also that was I've made part of it. I thought you found it. Yeah.
Is that the rest of yours?
Mhm.
It's going to be from the very back. That's us. Not sure. There you go.
Mr. Guards, there it is.
Either we have a change of lawyer at some point.
Maybe so. I think that could be it as well.
I'm sorry.
No, it's totally fine. I'm just not seeing it. So here we.
Okay. Yeah, it's short. I don't think there's anything. It's yours.
Oh,
All right, and so is state ready to proceed?
State's ready, Judge.
Defense ready?
I can be ready. Obviously, I have an objection, shockingly. I want to object at this time, Judge, to a couple of things. One is, I anticipate the state is going to essentially put on a miniature trial for these, alleged new offenses that he currently has a trial setting for, is my understanding. And we, essentially by doing it this way, the state is accomplishing two goals that we object to. And one is, converting him into a convicted felon for the purposes, arguably converting him into a convicted felon for the purposes of an actual trial for which he is presumed innocent. And we want our day in court with a jury. And then secondly, Judge, I object to the nature of how the state has pled this as both a manslaughter and a negligent homicide, because and then an aggravated assault. All three essentially, what this is a car accident case involving a death, certainly, but the way that it is formulated here, it makes it appear that there's multiple deaths for starters, and second, again, our concern, our objection is that we believe those types of offenses, is particularly in this case where there's not an aggravating factor of intoxication or something else about these offenses, that ought to be properly placed in front of a jury. And no offense to this court, obviously I have great relationship and trust in this court, but for his purposes and for his rights, we believe that this ought to properly, those offenses anyway, ought to properly be in front of a jury. And so we're asking for that. That's what I was hired to do, is to present this case to a jury or defend this case in front of a jury. And so we object to the nature of the proceeding here with this type of offense.
So let me just, before Mr. Coleman, there's nothing legally that prevents us from doing it this way. We've obviously, some cases we do this way, some cases we allow the cases to go to trial first and then the motion. So
Not saying it's a perfect objection, Judge.
okay,
It's,
I just want to make sure there's no legal prohibition from doing it this way.
I mean, I'm concerned about, I mean, again, obviously, if we went to a jury, Mr. Coleman would be welcome to ask for a lesser included of negligent homicide from a manslaughter indictment, et cetera.
So
Here-
the indictments, I don't disagree that the indictments that have been handed down by the grand jury are for an aggravated assault with a deadly weapon and a manslaughter. There is not an indictment for a criminally negligent homicide. I can and have in a motion and a hearing found true a lesser offense. But what I don't think would be fair is for me to be asked to find true both of those offenses, making it look like there were two separate offenses. And so we can handle that a couple of different ways, but it would look like if I were to find count one and count two, I think they're count one and count two, sorry. Yeah, count one and count two are in essence the same offense, just one a lesser offense of the other. So I don't think that's fair and would agree with that. But what I can do, I guess, is if in fact I find either of them true, it would only be one. And then the other I would find not true if I found one true at all. Does that make sense?
Yes, Judge.
Okay.
Understood.
Okay. So wouldn't want argument, obviously, that they're both true. The aggravated assault with a deadly weapon, is that a different complaining witness?
Yeah, definitely.
Okay, so that makes sense to have the separate one to me.
Yes, Judge.
Okay.
The other component is, Judge, in the indictment, again, this is part of the stickiness of doing it this way. What the state has alleged in their motion to revoke probation is essentially that he committed this offense of manslaughter, of negligent homicide, and of aggravated assault. Problem is, under the statute 21.15, the state is required to prove with specificity or plead with specificity what it is the nature of the recklessness or the nature of the negligence. And it's my position that certainly the motion to revoke probation does not plead those things with specificity. And so it just makes the conclusory statement. Again, this isn't a possession of cocaine case or something where it's just obvious that what the elements are here. There 21.15 requires proper notice of what the nature of the recklessness and or negligence is in any reckless or negligence case. And that's not done here.
Well, the indictment reads, did then and there recklessly cause the death of an individual in the manslaughter one. And then it goes forward to say by operating a motor vehicle, driving 72 miles per hour in a 30-mile-per-hour zone in a residential area at night, and by striking the vehicle. Is that not?
In the indictment, it does, but we're not pleading to the indictment here. I'm not trying to be overly difficult. I'm just being my normal difficult self. But to me, it's a problem because the motion to revoke probation that he's pleading to doesn't plead those elements with specificity.
So based on what I would say, based on obviously the nature of what the indictments allege, the level of proof obviously isn't the same, but I would anticipate and expect if I'm to find anything true, that the elements, every element of the offense as alleged in the indictment is proven by preponderance of the evidence, not just some random, the elements are the elements. I'm assuming that's what the testimony is going to be.
And on that, Judge, Your Honor, I agree. The elements are the elements. What I don't want to be is hamstrung or tied to the indictment in a motion to revoke probation.
Well, I think it's only fair that the elements of, the motion alleges manslaughter. So it's just, the law says manslaughter is, and in this case, the indictment says it's what it is. And so you're going to prove what the facts of this case are, you would allegedly. So there's no.
I just want to get out in front of any technical argument that Mr. Gertz may make about at the end of the conclusion of the presentation of the evidence and the motion to revoke probation context, that for whatever technical reason, we didn't prove up something alleged in the indictment. That's kind of what I'm trying to head off.
So it's obviously a relaxed standard, but I don't see how anyone who's going to come, law enforcement especially, or whatever the allegation is what the allegation is. So I would expect that the allegation pretty much as alleged.
Asterisk, notice what just happened. The judge didn't simply side with one attorney or the other. Instead, she stepped in to prevent what could have looked like double counting the same alleged conduct. That's a crucial legal safeguard because even in probation proceedings, the court wants the record to accurately reflect the allegations. This moment shows how judges often balance fairness with procedure before any evidence is even presented. And trust me, the testimony is where this case is really about to heat up.
In the indictment is what the facts would be. It's just a different level of proof. Okay, does that make sense?
So then, just to be clear, and again, I don't think he has to prove each of the manner and means of recklessness. I'm just complaining about the notice in the motion to revoke probation. So the
Okay, but you have the indictments, and so you know what the notice is. There's no surprise here.
I just making sure that's what he's relying on. Okay. Thank you.
Okay. All right. Anything else before we get started?
Not from the state. Before we begin, I just asked the court to take judicial notice of the entire file, including the conditions of court.
Any objection to that? I'll take judicial notice of the court's file.
Thank you.
Thank you. All right. Then any type of opening, Mr. Coleman, you may call your first witness.
No opening. State waives its opening at this time. The state calls Miranda Beza.